Welcome to Current Affairs. My name is Nathan Robinson. I am the editor-in-chief of Current Affairs magazine. I am joined today by Stephen Bright and James Kwak. They are the joint authors of the book, The Fear of Too Much Justice, Race, Poverty, and the Persistence of Inequality in the Criminal Courts, available from the New Press. Professor Bright, Professor Kwak, thank you so much for joining us at Current Affairs today.
Thank you for having us, Nathan.
Thanks, it's a pleasure.
Let's start with the title. What is the fear of too much justice?
Well, in 1987, the Supreme Court considered a case involving the racial disparities in the infliction of the death penalty in Georgia. And the evidence in that case showed that if the victim in the case was white, there was a much greater likelihood death would be imposed. If the defendant was black, there was a greater likelihood. And if you put those two together, if you had a case like the one that was before the court involving a black defendant accused of a crime and convicted of a crime against a white victim, the likelihood was much greater that you would get the death penalty. And the majority opinion was a very close case, 5-4. Justice Powell wrote for the majority, if we deal with racial disparities in the infliction of the death penalty, wouldn't we have to deal with regard to racial disparities in all the other kinds of crimes in the criminal courts? And Justice Brennan, in his dissent, said this was a fear of too much justice. And I think that explains a lot of things besides just the tolerance of racial discrimination, not only in the death penalty, but in jury selection and other kinds of cases. Our argument is that that's what the court should be doing. We should be dealing with those issues and deciding them rather than being afraid to tackle.
Yeah, you have some extraordinary quotes in the book that are of there's that one about if we found this unfair, then all kinds of other things would be unfair, and that might indict the entire system, which would be too much. We don't want to go there, so we can't even begin to consider the question of whether this narrow issue is unfair. You open the book with a quote from Winston Churchill, who says that, in fact, the mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. Professor Kwak, let me ask you, if that is the test of civilization, how is our civilization doing?
Well, I think, as you can imagine, we're doing quite poorly. I think, Churchill was right about some things, wrong about some things, but I think on this issue, he was definitely right. We, as a country, we like to pride ourselves on upholding civil rights and human rights. We like to think that human rights are a problem that other countries have, not a problem that we have. But I think that, as Churchill said, the real test is how a society treats people who are often poor, often from broken families, who have done bad things, and are essentially defenseless against the power of the state. And I think that, our country does pretty badly, and it does especially badly when you consider people who are poor, people of color swept up in the criminal legal system. We know that if you have a lot of money, you can mount a good defense. But one of the signal problems that runs throughout the criminal legal system is the way that we treat people who can't afford good lawyers, can't afford good representation. So Steve talked about the fear of too much justice in the context of the death penalty. That's one extreme of the criminal legal system. If we look at the other extreme, we have hundreds of thousands of people arrested, charged with relatively minor offenses, either misdemeanors or felonies that could get them a few years in prison. And, as we can talk about more later, most states, cities, and counties fail to provide most of these people with effective lawyers who have the time to do their jobs well. And why don't they? Well, one reason is the fear of too much justice. Everyone accused of a crime had representation, as good as rich people, or if every one of them had someone as good as Steve Bright to be the lawyer, the machinery of the criminal legal system, as we know, would grind to a halt. We would not have 95% of cases resolved with plea bargains. We would have many more trials, and the system just isn't equipped for that. So that's one reason. It's not the only reason, but it's one reason why we tolerate this level of inequality in the criminal legal system.
Now, your book goes through many different parts of the criminal legal system, from judges to prosecutors to public defenders, you have a chapter on mental illness and criminal punishment, on fines and fees. I want to go through some of these different parts because, you take each apart and show sort of where the injustices come in and how we might do better. You start with the prosecutor, and you have a quote in here that I think might be counterintuitive, because you say the prosecutor is clearly the most powerful actor in the criminal legal system. And I think it might be the instinct of an ordinary person that the judge is the most powerful person in the criminal legal system, because after all, the prosecutor can only make an argument, and then the judge decides whether or not to accept that argument. So, Professor Bright, what leads you to say pretty definitively there that the prosecutor is, in fact, the most powerful actor in the criminal legal system?
Well, for one thing, the prosecutor can decide not to charge at all, and there's absolutely nothing a judge can do about that. Or a prosecutor can decide to seek the death penalty in a case that really should not be a death penalty case, and there's nothing a judge can do about that. We have a couple of examples there of women facing the death penalty. Kelly Gisson-Danner was one, in which she and her boyfriend had conspired to murder her husband. They got caught. The prosecutor told them both, if you plead guilty and testify against the other, you get a life sentence. You can be eligible for parole after a few years. The boyfriend took it and testified against her. She did not, went to trial and got the death penalty. It was a case almost no other prosecutor in Georgia or even anywhere else in the country would have sought the death penalty in that case. But the prosecutor had the discretion to do it. Many years later, she had been a model prisoner. She had gotten a divinity degree. There were a lot of people, including the two children of the marriage. Of course, their father was the victim and their mother was now the person to be executed. They desperately pled for their mother not to be executed, but she didn't take the plea, and so she was put to death by the state of Georgia. Only the prosecutor has the ability to decide who gets the death penalty, who gets mandatory minimums, who's charged with a felony as opposed to a less serious crime. Prosecutor also has another power that I think many people don't think about. It's a power that no other person in the court system has, the ability to reward people for testifying the way they want them to. In other words, a person goes to the prosecutor, maybe charged with a burglary or robbery, whatever it may be, and says, if you will dismiss my charges, I will testify that the defendant in this case admitted to me that he did it. These are notoriously unreliable people, but they're called upon all the time. There are many people who really make a career out of being jailhouse snitches. And again, nothing a judge can do about that. The prosecutor decides to cut a deal with them, either dismiss their charges, give them less serious charges in exchange for their testimony. And unfortunately, many people that are in prison today and many people on death row got there in a trial where one of these jailhouse snitches testified.
I'd like to add one more thing. So Steve talked about the prosecutor's discretion to make charging decisions to seek the death penalty. And that's obviously very important in life or death cases. Again, it's equally important in small cases. The way most small cases are resolved is the prosecutor says, look, based on the facts that I can probably prove, I could charge you with these two felonies, which might have a mandatory enhancement. You'll get 10 to 15 years in prison. Or I can charge you with one misdemeanor. You'll get 6 months in prison, 3 years of probation. The defendant typically takes the deal, often because they don't have a lawyer who's equipped to fight the deal. They present it to the judge. The judge has to take it. I mean, there are very rare cases where a judge will inquire into a plea bargain, but when we're talking about garden variety criminal convictions, the judges are just rubber stamping them. And it's the prosecutor who decides the sentence, not the judge, because the sentence is determined by the charges and by the negotiation.
Professor Kwak, you are the author of also a wonderful book that I've enjoyed for a while called Economism, which is a critique of the overuse of economic concepts in our society. And I think you're right on that. But as I was reading this book, I couldn't help but think that the common assertion among economists that incentives rule the world has some truth here, because you highlight a lot of instances in which there are just bad incentives all through this system, in which judges have bad incentives, people have an incentive to plead guilty, People have an incentive to lie on the stand. There are just lots of ways in which people are sort of pushed into kind of bad behavior.
Yeah, I agree with that. I mean, I think that, one of the points of economism was that, economic thinking in itself is not bad, and thinking about the importance of incentives is not bad. It's just that, in certain policy contexts, it gets taken too far. One of those contexts, we don't discuss it in the books. Frankly, no one takes it seriously anymore. But in the 1960s and 70s, some of these, right-wing Chicago school economists, Judge Posner, one of them said, crime is a function of incentives. What criminals do, or what people thinking of committing a crime do, is they think, well, what's the percentage chance I'll get caught? They multiply that by the sentence they think they'll get, and they say, okay, I'm going to go ahead and commit this crime. Right. And that is absolutely preposterous, in small cases, big cases, death cases. If you look at the facts behind these events, it's clear that people are not making rational estimations of how much punishment they're going to get. But I think that, when we talk about how cases are disposed of, as you say, incentives are very important. We've talked about the incentives involved in plea bargaining, right? Because the defendant knows that if he insists on going to trial, he can get a much larger sentence. And secondly, the prosecutor is much better equipped to try the case. Incentives matter. Another situation we talk about is prosecutors and judges. Elected, virtually every district attorney in the country is elected. Judges are elected in a majority of states. Given the politics of crime and the law, prosecutors pose as basically people who put criminals away, and judges know that if they uphold defendants' constitutional rights in high-profile cases, they may face attack ads in the next election. So I agree with you that incentives do matter a lot in various parts of the system.
Yeah, let's talk a little bit more about judges and the ways in which judicial independence is actually quite limited. You point out examples in the book of, ways in which a judge can, we think the judge has autonomy, but a judge can in fact be punished for leniency.
Well, sure. I mean, one of the examples, or many examples abound, of judges who were voted out of office because a campaign was run against them, saying that they were soft on crime. Many times those campaigns weren't even fair. The judge was only one of several judges who ruled a certain way on a state Supreme Court and got voted out of office as a result of that. At the local level, one of the things that we see that's very disturbing is in a lot of places still today, the judges appoint the lawyers for people accused of crimes. And very often they give people incompetent lawyers. We know that in Houston, for example, when someone runs for judges, the lawyers there contribute a lot of money to the judges' campaigns. And once someone's elected judge, many of them then appoint those lawyers to cases, including death penalty cases, and then pay them very generously for often doing very poor work on behalf of their clients. In other words, it's a political patronage system. It's not a system based upon giving people a fair trial, giving them a zealous lawyer, or any of the things that we expect the system to provide.
You cite an extraordinary quote from a former Chief Justice of the Alabama Supreme Court who, after she retired, wrote, "I was Alabama's top judge. I'm ashamed by what I had to do to get there," explaining that it can be quite explicit. She said donors want clarity, certainty even, that the judicial candidates they support view the world as they do and will rule accordingly. The money in this, we talk about money in politics, but generally I feel like judicial elections are kind of overlooked in that.
Yeah, they are. I think there's another great quote in which, I forget who it was, but somebody said, the people who basically with money to spend have figured out that it's a lot cheaper to buy a Supreme Court justice than to buy a whole legislature. The whole state legislature, and often the justice can do a lot more for you. So I think that, one of the things that we've seen in the past 30 to 40 years is, two things. One is obviously increasing polarization in American politics, and increasing attitude on both sides. I think more the Republicans, but to some extent on both sides, an attitude to see every piece of the governmental system as a battleground to be fought over. And then we've also seen the realization that judges, particularly state Supreme Court justices, play a fundamental role. This is common knowledge now. You think about the Supreme Court of Wisconsin, the Supreme Court of North Carolina, and these swing states. Everyone knows that these are extremely important political institutions that will decide a huge variety of cases. However, one thing we talk about in the book is that when it comes to running a campaign against a judge, nothing works as well as demonizing them as being soft on crime. So judges get attacked for, as Steve said, they get attacked for basically making correct decisions, calling out prosecutorial misconduct that requires a new trial for somebody. Person will probably be convicted again, probably go back to jail, but simply, ruling on behalf of a defendant can become a fatal error from a political perspective. That's, certainly contributed to the polarization of the judicial system and also to the hesitancy that judges may have to uphold constitutional rights and independence.
There's one other thing I wanted to ask you about prosecutors, actually, which was, I think people have heard of, or it's become a little more common knowledge now that the plea bargaining process can be quite coercive. But one of the things that you discuss in this book that I think is less well understood by the public is the level of control of information that prosecutors have and the way in which evidence of innocence can be concealed. And the perhaps you could talk about that a little bit. And going back to what I was saying about how you say the prosecutor is the most important or the most powerful actor in the system, it is not just we discuss their charging decisions and plea agreements, but could you talk a little bit about the information that they have control over?
Sure, and that's a very good point. And again, one that many people don't understand is in many states, it's different from different states, but in many states, all the work that the police have done, all the investigation, all the witness interviews, all the grand jury work, all of that the prosecutor has, and in many places doesn't have to share it. In North Carolina, they passed a law at some point that said after a death penalty case, information in the prosecution file had to be disclosed. And about 10 years after that, 10 different people who had been sentenced to death were given new trials because of information that was in the prosecution file that had never been disclosed to the lawyers for those people. First of those, Alan Gell, went to trial and was acquitted in a very short period of time, clearly was not guilty of the crime. After that, North Carolina passed a law that said before trial, the prosecution had to disclose everything in the police and prosecution files. And that's something that really, in this day and age, ought to be required everywhere. I mean, in a civil case where we're talking about a lot of money, everything is disclosed. Their depositions, their exchange of documents, their requests for admissions. There's all this information so that by the time of trial, both sides know everything there is to know about that dispute. And yet in criminal cases where we're talking about life and liberty, we still have trial by ambush in many places. And we see that one of the results of that is, as you know, the conviction of innocent people.
Yeah, I wanted to add that. So, as you know, there's been a rule since the 1960s saying that prosecutors have to turn over potentially exculpatory evidence to the defense attorney. So we have that principle in the system, but the problem since the 1960s has been it's up to the prosecutor to decide whether or not evidence is favorable to the defendant. And prosecutors, first of all, they have a bias in favor of thinking, they think the guy's guilty. Right. They have a bias in favor of thinking that it's not exculpatory information. And secondly, the penalties for failing to turn it over for the prosecutor personally are generally zero. So we have a system that depends on the intentions and behavior of the prosecutor. And, it's a system that clearly is not going to work, which is why I think North Carolina did the right thing by requiring full file disclosure.
It's a little paradoxical because presumably if they actually thought it was exculpatory, they wouldn't be prosecuting the person. So there aren't going to be that many. There was a case in here in New Orleans, of course. In fact, Professor Bright, when I took your class, John Thompson came to speak to our class, right. And I know that he was kept on death row for many years because the office of Harry Connick Sr. had failed to turn over exculpatory evidence. Of course, there's not much you can do about it because you don't know what you don't know.
Well, and John Thompson is a sobering case because he came within a very short time. He had an execution date. He was going to be put to death, and only because this law firm that had taken his case sent somebody to take one last look through these files, and lo and behold, found this document that showed the blood type of the assailant in the case, and it wasn't John Thompson's blood type. So at the very last minute, he was exonerated, but he could have very easily been put to death either because that document wasn't ever found or because they didn't even look for it in the first place. So again, it's a very sobering case. And tragically, there were a number of other cases out of the New Orleans District Attorney's Office of people who were later exonerated. Curtis Lee Kyle's one that comes to mind, who had had several trials, hung juries, finally convicted, and then the Supreme Court of the United States said failure to disclose certain evidence required him to get a new trial, and ultimately charges were dismissed.
Last time you were on the program, Professor Bright, we discussed extensively the quality of counsel available to people, to poor people in this country. That obviously forms, there's a lot about on that topic in the book. So I don't want to dwell in this conversation. Again, people can go and listen to our previous conversation about that. I want to talk about some of these other parts of the system today. In particular, I'd like to talk about how difficult it is to get an error fixed. You have this quote, I think it's from Justice Blackmun, about the Byzantine morass of arbitrary and unnecessary and unjustifiable impediments to the vindication of federal rights. One of the things I remember most from your death penalty course, Professor Bright, is just how complicated and difficult it is, even when there has been an obvious failure or an obvious injustice or a violation of proper legal procedure, to get your actual guaranteed rights vindicated.
Yes, and very often the reason the rights were vindicated was because of something the prosecution did. And yet the Supreme Court, when it was becoming clear that a lot of death penalty cases were going to be set aside because of constitutional violations, the court began just making up out of the whole cloth all these procedural requirements, and then saying that because the lawyer didn't object or the lawyer didn't do one thing or another, therefore we're not going to look at the particular issue in the case. And they just kept tightening that up and got it tighter and tighter and tighter until now, very often the courts just won't even examine constitutional violation that took place in a case.
Professor Kwak, maybe you could give us some examples of ways in which, you document lots and lots of instances in the book of, things that have obviously been done wrong and ways in which people have been treated unfairly or had their rights violated, but they struggle to actually get a remedy.
Sure. I think that the most fertile ground for that kind of tragedy is ineffectiveness of counsel, right? So we talk at length, and you've talked about this with Steve in the past, about the poor representation that many people have on trial and on direct appeal. But, one would think that those errors could be fixed, right? If your lawyer is drunk, if your lawyer sleeps in court, these seem like pretty cut and dried cases. But, the challenge is that although the Supreme Court said in the 1960s that you have the right to a lawyer if you're facing any potential loss of liberty, it wasn't until the Strickland case in 1985, I believe, that the Supreme Court had to decide what it meant to have an ineffective lawyer. And in Strickland, the Supreme Court set the bar very low for the performance of a lawyer. They said lawyers are presumed to be competent, and decisions that they make are presumed to be strategic. So, for example, the decision not to cross-examine any of the prosecution's witnesses could be presumed to be strategic. In other cases, the courts have said that essentially not putting on any mitigating evidence in the penalty phase of a death sentence trial was strategic. So, first of all, if you're trying to prove that you had an incompetent lawyer, you have to prove that they were really, really bad. And then secondly, you have to prove that a better lawyer would have made a difference, which is extremely hard to prove because nobody knows.
Yeah, right.
Nobody knows. And the other thing I should have said first is to do all this, you need a good lawyer, right? And ineffectiveness claims are typically made in state post-conviction proceedings where you have no right to a lawyer. For example, in certain states, will give you a lawyer for a post-conviction petition in certain kinds of cases, such as death penalty cases. So to wrap up the previous point, most people who have been convicted because of incompetent lawyers don't have a lawyer to make an ineffectiveness claim. Some of them do, but that lawyer doesn't necessarily have to be competent because the right to counsel does not apply to a lawyer provided to you for post-conviction proceedings by a state. So, for example, in Texas, that lawyer just essentially has to be bar certified and not be right out of law school to be considered competent. Even if they then proceed to behave incompetently, you have no claim. So that's just one family of the many ways in which the Supreme Court, in particular, U.S. Supreme Court, has made it difficult to fix errors. I'll just say one more thing, which is that probably another very major problem was the Anti-Terrorism and Effective Death Penalty Act of 1995 or 6, I forget, which said that federal courts have to show great deference to decisions of state courts, and also tightened up the ability to get federal reviews. Because for many decades, the federal courts were the avenue by which people who had been, say, sentenced to death in state courts could have their convictions overturned. EDPA and Supreme Court decisions since then have made it very, very difficult. So it's only once in a blue moon that state court decisions get overturned in federal court.
And as I understand it, Professor Bright, you have, you've taken a lot of capital cases in your life, and I know that you have taken a lot of appellate cases where you have had to work with the record of a bad trial lawyer and try to undo the damage that was done. And I take it that one of the reasons why you so heavily insisted on the need to make sure that everyone gets competent counsel at trial. I mean, it must have been just incredibly frustrating for you to look at the record of a case and know that you could have and would have done it differently at the trial level, but now you're stuck.
Well, and often you look at a record and say that any competent lawyer would have done it differently. I mean, there are many places in this country, in particular the places sending a lot of people to their death rows, like in Alabama and Texas and some other states, where there are no public defenders, just some local lawyer is appointed to represent someone. And often these lawyers don't even specialize in criminal law, let alone the subspecialty of capital defense. And so you have lawyers that are just clueless, unfortunately. Unfortunately, you also have lawyers who have alcohol and drug addictions that show up in these cases many times. And as James explained a moment ago, if you do come in later and you try to show here are all the things that could have been done, here are all the facts that should have been proven, here are all the questions that should have been asked, you basically substitute trial by judge for trial by jury. Because even if you show that the lawyer was very deficient and that the representation was totally unreasonable, the judges will say, well, we don't think it would have made a difference. We think he would have been convicted anyway, or we think the client would have been sentenced to death anyway. Well, there's no way they would know. They weren't there at the trial. They didn't see the witnesses. They didn't sit with the jury. They don't know how the jury assessed the case. But that's the system that we have. And so the first hurdle that a person has is getting a lawyer. James said a moment ago, many people who are convicted never have a lawyer to raise the competence of the lawyer they had at their trial. And then if you do, and more often it's going to be in death penalty cases, this deference that the federal courts have to the state courts is also going to kick in, so that an awful lot of very deficient representation is allowed to go uncorrected.
You've been talking there about death penalty cases, obviously the most serious category of cases, but you have in your book a lot of documentation about just the everyday extraction of money from poor people by courts, by private prisons, a category of corporation that I didn't know existed until reading the book, which is the probation company. I didn't even know there were probation companies, but I feel like that is an industry that shouldn't exist.
Yeah, I mean, I think that this is, let's say two things about it. This is a reflection, I think, in part on the nature of government in the United States. So a couple things that happened. One is that beginning in the 1980s, perhaps in the 70s with Margaret Thatcher, but certainly in the 80s with President Reagan, there has been a prevailing view in this country, held by most Republicans, and I would say many Democrats, that the private sector can do things better than the government. So given the choice, we should be outsourcing government functions to private companies. And then I think that the other thing I'll say about government in this country is that there is a lot of legal corruption at all levels of government. By legal corruption, essentially, I mean companies buying favors from politicians through legal means, such as contributions, lobbying campaigns, implicitly promising people jobs as lobbyists after they leave government and so on. And so when you add those things together, what do you get? You get private probation companies that contribute money to politics at the local and state level, and they convince, say, the head of the Department of Corrections, and they convince a group of state legislators that probation functions should be outsourced to the private sector. And how does this work? Well, if you have fines and fees that you can't pay, the judge will say, that's fine, you can pay over the next 12 months, but the money's going to be collected by this private probation company, and you have to pay them a fee of $40 a month for their, quote, services, end quote. So now the poor person is now just even more in debt and is less likely to be able to pay off their fines and fees. When you add in the probation fees, a year goes by, they're behind on their debts and they get sent to jail. So that's what happens. And the reason this is kind of so egregious and doesn't work is that, I agree that in many parts of the economy, private companies do a good job of providing goods and services to customers who are willing to pay for them. This is not one of them. Because when you talk about private prisons, for example, the decision to hire a certain company to manage a prison is not being made by the people who are in prison, right? It's being made by the Corrections Department and the legislature. And they're making the decision not based on who can provide a safe environment and decent food at a reasonable cost. They're doing it based on, who takes them out to the nicest dinners when they're in the state capital. I mean, you can criticize our government as much as you want, but in the old days, probation officers were public employees whose job was to help you get your life together and make sure that you were able to get a job and keep it. And now they are bill collectors who use the threat of jail to extract money from families.
I want to conclude with one other area here where you really document a pretty, I can't think of another phrase that messed up part of our system, pretty messed up part of our system, which is I think people have heard that jails and prisons are where we house the mentally ill in the United States. But what you document here is, you really expose just how perverse it is to have people who don't even understand what is going on being put on trial. And you make what I think should be the uncontroversial assertion, people who cannot understand the legal system should not be processed through the courts. But they are processed through the courts every day.
Well, yes, and this again goes to both the most serious cases and the most routine cases, as we've talked about throughout. The largest mental institution in any community is the local jail or the local prison. And the prisons and jails have just become a dumping ground for everything from homeless people who may be schizophrenic or bipolar and who are not being medicated or don't have families to look out for them. And they end up being arrested, often on the most petty kind of crimes. I should say, parenthetically, people who have mental disorders are much more likely to be victims of crimes than to be perpetrators of crimes. But there are times, tragically, when people with major mental disorders do commit serious crimes and are processed through the legal system. Many of those people would not have been there if they had been dealt with appropriately in the community beforehand, but they're homeless because we don't have any community mental health centers in most communities around the country. And so, as you say, there are people who are being tried, sent to prison, even sent to death row, who are profoundly mentally ill, don't understand what's going on, and really are not people who should be in prison. They should be in some sort of mental institution.
Well, we don't have time today to go through all of the various facets of the criminal legal system that you dissect in the book. You also talk a lot about juries and how they're composed and racial discrimination in jury selection. The book is a pretty comprehensive and disturbing look at our system today, but you do, for each aspect of the system, recommend pretty obvious and basic ways in which it could change, and in which, if we did not have the fear of too much justice, we could, in fact, provide justice for all. So, Professor Bright, Professor Kwak, thank you so much for joining us on Current Affairs today.
Nathan, thank you for having us.
It's been a great pleasure.
The Current Affairs Podcast is a product of Current Affairs Magazine. If you are not subscribed to Current Affairs Magazine, visit currentaffairs.org/subscribe today and get our glorious print edition. The Current Affairs Podcast is released regularly every week on patreon.com/currentaffairs. Thanks for listening.